Okay. Hey, everybody. Thanks for joining us. On who's going to be doing the training today is a friend of mine. She's a title agent with Ekko Title in Lake Ridge. Heidi is the one that I asked to come in when I teach the 8-hour mandatory class through PWAR. I ask Heidi to come in and do the contracts because usually there's a lot of upheaval and turmoil, especially what's been going on the last few months. And so I thought it would be really beneficial if she did this. Again, she's practiced at doing this. She's actually on an advisory committee with the forms committee. So this is important. And you've got somebody that I see as an expert in all of this doing the instruction. So Heidi, take it away.
All right, thanks so much, Mark, and thank you guys all for being here. Like Mark said, I'm Heidi Marine. I'm the settlement attorney for the Ekko Title office in Lake Ridge. I've got about an hour of content here today, but like Mark said, he's going to record it. So if you have to jump off, it'll be available later. And just a real quick shameless plug for the Ekko Title Facebook group. If you guys aren't familiar with that, this is a QR code on the screen with the link to join. It's a great resource for realtors to post questions. One of the Ekko attorneys will answer the questions, especially right now with all of these changes going on. It's helpful to see what other people are saying and doing for better or worse. It's just good information. So I would definitely recommend that if you guys aren't familiar with that so far. Go ahead.
And I'm just going to tell you, I'm a member of that group. And so I look at it routinely on different things that are being said. And as Heidi said, for better or for worse, sometimes I go, oh, that's great. And other times I go, ah, ah.
Right. Just like anything on social media, right? You gotta
That's true.
take it with a grain of salt sometimes.
Right.
But yeah. And also my contact information is on the screen here. If you have any questions later, feel free to reach out to me. I'm happy to go through any of this again, because I know even for me, it took me a couple times hearing it to really have it all sink in. So sometimes it's helpful to hear it over and over again. But all right, well, let's dive right into it. This is the agenda for what we're going to go through on the class here. So there are basically 5 changes that we need to be aware of that went into effect July 1st. And then we'll see that some tweaks were made that are actually being released today. So even there's changes to the changes already. So that can give you a sense of how this is going so far. But so first I want to talk about some non-NAR settlement related changes. Okay, these are the easy ones, quote unquote. So first, to the residential sales contract, they have added a definition of what is a business day in the definitions paragraph 27 of our sales contract. And this is great, especially from a title person perspective, because we didn't have that before. And so sometimes the deadline to deliver an earnest money deposit would fall on the weekend and we're not open. And so it would create this whole issue. So we now have a definition of business days. So we will look at that as it applies to the deposit paragraph as well as the settlement date paragraph. And then secondly, to the sales contract, we had some big changes to the Virginia Resale Disclosure Act. So this session, the legislature made additional changes. They had really overhauled the whole Resale Disclosure Act last July, and now they're kind of cleaning up some of the unintended consequences as a result of those massive changes. So you will see now in paragraph 8, the Virginia Resale Disclosure Act, the period for the buyer to cancel the contract after receiving the resale certificate is now fully negotiable. It's just a blank. So you can put any number of days in there now, and we'll look at that and talk a little bit about what that means as well. And then the listing agreement, before we just had one time frame in the listing agreement, the listing period. Now we have an agreement term and a listing term, and we are supposed to enter the listing into MLS within 2 days of the listing term. So we will look at that change as it affects when that needs to be entered into MLS. And then if anybody does business in Loudoun, okay, last forms change in January, we got the new Airport Impact Overlay District notice, and the legislature has decided No, realtors do not need to disclose if the property is near a airport, and so they have gotten rid of that notice. So if you do business in Loudoun, just know that that is removed now. And then we will talk about the NAR settlement related changes. Okay, these are the fun ones. So the listing agreement, all right? So if you watched a forms change presentation between July 1st and now, you saw that there were 3 paragraphs in the listing agreement that had to do with compensation, okay? They have gotten rid of 2 of those already, all right? So if you already saw the forms changes from July 1st, now as of today, okay, as of August 14th, if you go into the forms library, you will see the new version of the listing agreement. It was just released today. We now only have 1 paragraph talking about listing broker compensation, okay? So we'll look at that. And then there's a new paragraph 6B, which is additional listing broker compensation for unrepresented buyers. So we'll look at that. So that paragraph 7 that they had added, which was for seller paid buyer broker compensation, that paragraph is now gone, okay? And you are to use a new addendum to the listing agreement for optional buyer broker compensation. So we'll look at that and how that works. And then they had, again, added a paragraph 8 to include a potential seller subsidy in the listing agreement, and they have removed that completely. So there is no more mention of the seller subsidy in the listing agreement. Doesn't mean you can't have it in the contract, right? We still have that paragraph in the contract. It just is no longer in the listing agreement. So a lot of moving parts here, but it is all for the better, okay? So also the residential sales contract, if you will notice on page 1 now, we have line 2E, which is a brand new line as of July 1st, the line for seller payment towards buyer broker compensation. And it also includes third-party beneficiary language. So we'll look at that in detail. And then the buyer broker agreement, which specifies the amount the buyer is expected to pay towards their agent, right? And specifies that the buyer broker cannot receive compensation in excess of what the buyer has agreed to pay to the broker. And it, as of July 1st, had a checkbox to direct the buyer broker to request seller contribution towards the buyer broker compensation if that was something that a buyer needed. They have now removed that checkbox. So again, if you've heard this presentation between July 1st and today, you will have seen that, and that is now gone. So again, lots of moving parts, but once we look at it, it'll make a lot more sense. But I just wanted to give you the broad overview there to start, okay? All right, so let's jump into, again, the easy ones first, the non-NAR settlement related items. So form change number 1 that I wanted to look at to the residential sales contract, 2 things, right? The definition of business days and those changes to the Resale Disclosure Act. So paragraph 27 now, if you look at the newest version of our residential sales contract, 27C says business days means any day that is not a Saturday, Sunday, legal holiday, or day on which the state or federal government office is closed, okay? That's brand new. Before we just had days. Days means calendar days, right? So this is great, and it applies anywhere that business days, that word is included in the contract, which is just in the deposit and the settlement paragraphs. So before we had a definition of business days, if let's say you ratified the contract on a Tuesday, right, for example, and it says the EMD is to be delivered within 5 days, right? Wednesday, Thursday, Friday, Saturday, Sunday. So Sunday, the EMD is due, but Ekko Title's not open, right? So how am I going to deliver my EMD and get a receipt saying, you know, I have delivered my EMD? So now it automatically says business days, right? So if we ratify on Tuesday and it says the EMD is due in 5 business days, we count Wednesday, Thursday, Friday, skip Saturday, Sunday. So then you've got Monday, Tuesday. So you have until Tuesday to deliver the earnest money deposit. The interesting part of this definition, and again, you've got to look at it a couple times before it makes a lot of sense. Everybody understands Saturday, Sunday, legal holiday, but what does a day on which the state or federal government office is closed mean, right? What is that if that is not a legal holiday? So it could be a snow day, right? We've got days where, our office is closed, the courthouse is closed, even though it is not a holiday because of some sort of snow emergency, right? Also, what we have every year is the day after Thanksgiving. And I can tell you every year I've got an issue where EMD is due. And the question is it due that Friday? Is that a valid date that something can be due, right? And so now this is clear, right? That day is not a legal holiday. It's not a Saturday or a Sunday, right? But all of the government offices are closed, the courthouses are closed, the title companies are closed, right? So it's now much more clear when that earnest money deposit will actually be due. So this is great. And then same thing for the settlement paragraph, right? If you accidentally pick a day that is not a business day for settlement, before, right, it was a little bit unclear. It would just said the settlement will be on the prior business day. And now it's really, really clear. It just says if the settlement date falls on a day other than a business day, settlement will be the prior business day. So super easy. So that's a good one. All right. So a little bit about the Virginia Resale Disclosure Act. So two things I wanted to bring up here. First, when we look at paragraph 8, right, of our sales contract, it specifies what a seller needs to do, right, if a property is being sold that is in an HOA or a condo. So it specifies, right, let me get my pointer here, see if you can see that. Right, in any contract for the resale of a unit in a common interest community, meaning HOA or condo, right, the seller shall disclose that 1, the unit is located in a common interest community, and 2, right, the seller or seller's agent, okay, is required to obtain from the association a resale certificate and provide it to the purchaser or purchaser's agent. So this highlighted language is new to the statute and new to the contract. However, it is not a new idea, right? The agent is an extension of the client, right? And so under agency law, all of these principles apply, but it wasn't clear in the language of the statute or the language of the contract before. So now we know, right? The seller or the seller's agent is able to order that HOA resale certificate. We had some persnickety HOAs out there, right, which would say, okay, only the seller, only the owner of the unit can order the resale certificate and give agents a hard time that we're trying to do that. So this makes it really clear that they can't do that. And then same thing on the delivery side, right? Either that packet can either go to the purchaser or the purchaser's agent, and it starts the clock, even if that delivery paragraph only includes the purchaser's email. Delivery to the purchaser's agent is in effect delivery to the purchaser. And so that starts the clock same. So that makes it more clear there. And then about the days, right? Okay, so last July, like I mentioned, the legislature merged the resale disclosure provisions of the HOA and Condo Act into one act to try and make it easier and more streamlined to know where to look to find out what the rules are regarding resale disclosures. And merging those two things together had some unintended consequences, right? So from last July to this July, right, we were in a situation where the language that said a buyer may not waive their right to cancel the contract upon receipt of the HOA disclosure packet, that had been removed last July, right? So we were in this weird time now for the last year where a buyer could technically waive their right to cancel the contract upon receipt of the resale disclosure packet. So the legislature, we expected to just put that language back in and not really do a whole lot else, but they didn't do that at all, okay? Instead of just putting that language back in, they have now made it fully negotiable as to how many days the buyer has to cancel the contract upon receipt of the resale certificate. So now we have two blanks under that paragraph 8 that you would fill in, right? The first line here pertains to when you receive the packet with the ratification of the contract or prior to ratification of the contract. And then the second line here is for if that resale certificate is received after ratification of the contract, right? And then they gave us a great default sentence here. If the timeframes in this paragraph are left blank, they default to 3 days. So if you put nothing in there at all, we're back to 3 days, which is where we were before. The interesting thing to think about regarding this is, what does 0 days mean, right? If we put 0 days in this line, what are we saying? Are we waiving the right to receive the resale certificate? Are we waiving the right to cancel, right? No, okay, so if you think about it, right, how do you calculate the days, right? So let's say, again, on Tuesday, the buyer receives the resale certificate, and we have 3 days listed here. We count Wednesday, Thursday, Friday, right? And days under the Resale Disclosure Act is defined as calendar days. So it goes through 11:59 p.m. that day. So they have, if anytime they get it on Tuesday, right, they have Wednesday, Thursday, Friday until 11:59 p.m. to cancel the contract, right? What if instead you put 0, right? You are starting on Tuesday, you have 0 days to cancel the contract. Day 1 is not until Wednesday, right? So the legal argument there is that any time on Tuesday is still day 0. So you still have the ability to cancel the contract upon receipt of that resale certificate through 11:59 p.m. on the day that it is received. So I think, it's easy to say that from, a legal standpoint. I think in practice, I'm sure it's a little bit more tricky to finagle, but that is the basic argument there, right? Day 0 is the day that packet is received, and you don't start day 1 until the next day. So even if you put 0 in there, it's not a waiver, right? The seller still has to provide the resale certificate. The seller still has to comply with any notices of violations, just like they did before, right? And pay any special assessments and back dues, all of that. It's just now we are able to fully negotiate the number of days that the buyer has to review that resale certificate. Okay, so let's change here to form change number 2. So this is the listing agreement, and again, not into the commission related items yet. This is just, now we have an agreement term and a listing term, okay? So the agreement term is what used to be the listing term, right? Just to make it more complicated. The agreement term is just the term of the agreement, right? The agreement will run for the period commencing upon signatures by all parties and expiring at 11:59 p.m. on blank date, right? Now the listing term, right, states the listing term begins when seller instructs broker to allow any potential buyer to learn about the property. And the important part here, listings shall be entered into the MLS within 2 days of the start of the listing term, okay? So they've basically gotten rid of the 21-day limit on coming soon, right? Now coming soon can be as long as necessary to benefit the seller. And we know as soon as the seller says any buyer can learn about this property, that is what kind of starts the clock for when we need to enter the property into the MLS. So Bright actually put out a really useful flow chart, and this is a QR code with a link to look at that if you are interested. It goes through all the different possible scenarios of how the seller is instructing you and how to enter it into MLS, whether as active or coming soon or internet no, all of those scenarios. So I would definitely recommend you check that out if you have any questions, or if you look at it in regards to a particular scenario that you are dealing with.
So Heidi, can I ask a quick question?
Yes, please do.
So with the requirement from Bright on the office exclusive, how does that get fed into this?
Yep. So it's a little bit out of my area of expertise, to tell you the truth. I don't deal with that specifically, so that may be something that you might want to speak about.
I will, but I didn't know if you had it, if you had any
Okay.
kind. So I'll
Yeah.
deal with all that. So that's okay.
Okay.
Thanks. Bye.
Okay. Okay, so let's switch gears to the fun stuff here. So let's talk a little bit about the NAR settlement terms. Okay, so we've all heard enough about the lawsuits and the DOJ and everything that's been going on. NAR has reached a settlement to globally resolve the DOJ investigation and all of the lawsuits and put all of this to bed. So it's important to look at what are the actual terms that they have agreed to in order to, like I said, put an end to all of this. So the crux of the plaintiff's class action lawsuit kind of boils down to the NAR's clear cooperation policy and an allegation that that is anti-competitive. Okay, so the clear cooperation policy was the requirement that in order to list any property in the MLS, you had to make a blanket offer of cooperative compensation in the listing itself, right? So the settlement has completely reversed that policy. Okay, so first, right, number one, eliminate any requirement that MLS participants must make offers of compensation to buyer brokers in MLS listing. So the requirement is gone, right? Second, prohibit MLS participants from making offers of buyer broker compensation on the MLS. So it's not enough to just eliminate the requirement. They are now specifically saying we are prohibited from making offers of buyer broker compensation on MLS. Third, require MLS to eliminate broker compensation fields and prohibit sharing of offers of compensation to buyer brokers via MLS. So today's the day on that, right? So today's the day, August 14th, where the cooperative compensation fields are coming down and will no longer be on MLS. Fourth, agree not to facilitate any non-MLS mechanisms for making offers of compensation to buyer brokers. So what does all of this mean, right? We just cannot make offers of cooperative compensation through MLS. You can call and talk about it. You can text and talk about it. You can email. You can rent a billboard. You can put it on your printed materials. You can put it on your Facebook page, on your website, right? But you just can't use MLS in any way to convey any information about the cooperative compensation. Also can't say in MLS agent remarks, right? Please look at my website for an offer of compensation, right? Or call me for an offer of compensation, right? So you're still, in some way could be perceived as using MLS to make that offer of compensation. So all of that is gone. The creativity of the agents since this whole ruling has come out has been amazing. And it's funny, but not funny. Some of the things that people have come up with. I don't know if you guys have seen where, some people were saying, well, we're going to write the offer of compensation on the couch cushion, and that's going to be one of the pictures in MLS, right? Or other people saying, I'm going to, capitalize certain letters in the listing description to convey the commission, right? So I applaud the creativity, but again, no, right? We can't in any way use MLS in order to convey an offer of cooperative compensation. And also, MLS corresponds with Zillow and, Redfin and all of those other internet aggregators to pull information. So also it cannot be pulled to any of those platforms that correspond with MLS. So it has to just, again, be on a conversation, on your printed materials, on your own website. All of that is still just fine. And then some additional settlement terms, right? So in addition to that complete reversal of the clear cooperation policy, Now MLS participants are required, if they're working with a buyer, they must enter into a written agreement before the buyer tours any home, which in this area has been how it is for a very long time. So that's nothing new here, which is great. Also, buyer broker agreements must include an ascertainable payment amount, okay? Either a dollar figure or a percentage figure. Can no longer say per MLS or whatever the seller is willing to pay, right? It has to be an ascertainable amount of money that the buyer is agreeing to pay their agent, okay? 7, buyer broker can only receive compensation from any source in the amount stated in their buyer brokerage agreement. And we'll see that when we look at the changes to the buyer broker agreement. Number 8, prohibit agents from advertising their services as free, of course. Number 9, brokerage agreements must disclose that commissions are fully negotiable, which we already had in there. And then 10, buyer brokers must not filter listings based on the existence or level of compensation offered to the buyer broker. So again, one of the main, cruxes of the plaintiff's class action lawsuit was, that there was steering going on, right? Where buyer brokers would steer their clients towards listings that offered more compensation and away from listings that offered less compensation. And that just can't happen. And that field is going to be gone, right? So it's going to be harder to steer in the future. This is just my summary. I definitely would recommend, if you're interested in the 30-page settlement itself, it's available online. If you just Google it, it'll come up. So definitely, if you need to fall asleep at night, that is great reading.
So real quick, after this is over with, Heidi, our firm is doing a meeting on the settlement too. So people will go basically directly from this into that.
Great. Well, that's good. The more information, the better, right? Okay, so let's turn to the settlement related forms change. So form change number 3 that I wanted to touch on today is the listing agreement compensation paragraph. So paragraph 6 in the listing agreement is now listing broker compensation only, right? So remember, before there was a lump sum of compensation, right, which included what is going to the listing broker, right? And then some may be shared with a buyer agent, right? So we have completely removed buyer broker compensation from the paragraph here, okay? So this is only talking about what the seller is paying the listing broker, okay? So same kind of format as before, right? Seller will pay broker, right? Meaning listing broker compensation of either a percent of sales price or a dollar figure, or a percent plus a dollar figure, if during the agreement term, anyone produces a buyer ready, willing, and able to buy the property. So again, just really important to kind of grasp the concept that this is only the listing agent's compensation, listing broker's compensation. It is no longer a cooperative compensation paradigm where a portion of this is shared with the buyer broker, okay? This goes on, right? So that was 6A. It goes on to 6B, which now has an optional, right, checkbox here at the beginning of 6B. So you check it if it applies. For additional listing broker compensation for unrepresented buyer. So if anyone produces a buyer ready, willing, and able to buy properties, and such buyer is not represented by a broker at the time of ratification of the sales contract, seller will pay broker the following in addition to broker compensation. So this is more money, right, that a seller would need to pay in addition to what they've already agreed to pay the listing agent if the buyer comes in unrepresented, okay? Again, it's optional, right? You want to check the box if it applies. I think, to me, right, the conversation to have with the seller is there's going to be more work for the listing agent to do if a buyer comes in unrepresented, and to go through all of those things that a listing agent is going to end up doing if an unrepresented buyer comes in. And so, that makes it really clear why the listing broker would want to receive additional compensation in that scenario, okay? And again, this is not a dual or designated representation scenario. This is the listing broker is only, representing the seller, right? And maybe doing ministerial tasks, right? And not providing his professional judgment or advice to that buyer. But those ministerial tasks, right, take up a lot of time and effort. And so it makes sense that you would want to be paid for that. So I think that this is, something that you would want to consider talking about on every, listing appointment, because especially now that buyers are going to be expected to pay their own agent, right? We may see a lot more unrepresented buyers potentially, right? So it's just a good thing to bring up in the beginning and set the expectation for the potential payment. Okay. The remainder of paragraph 6 is the same, still has the variable rate compensation field, the listing broker service fee, the retainer fee, and the earlier termination. That is all the same as it was before. But now, okay, paragraph 7, right, is totally different. Okay, so again, if you saw this presentation between July 1st and today, paragraph 7 had an amount that was set forth that a seller would be willing to consider paying towards buyer agent compensation. Okay, so we were putting in the listing agreement an amount, right, that the seller may be willing to pay towards the buyer agent compensation. Now it doesn't say an amount at all. Okay, it's a bunch of CYA language, if I can just be frank about it. But it says optional seller paid buyer broker compensation. Generally, prospective buyers may retain a broker who represents their interests only, which is a buyer's broker. Seller has the option to agree to pay some or all of the fees of buyer's broker in this transaction, which will be payable upon settlement. Seller has no obligation to pay buyer broker compensation. Buyer broker compensation is negotiable and will ultimately be determined by a ratified sales contract between the seller and the buyer. So again, a bunch of CYA language, which is very important, right? Because pursuant to the terms of the settlement, we've got to have something signed by the seller saying they know, they have been told and told again that they have no obligation to pay the buyer broker compensation. And then paragraph B here now has a checkbox, right? So seller either authorizes or does not authorize broker to disclose to prospective buyers and brokers representing buyers of seller's willingness to negotiate with buyer during seller's payment of, in whole or in part, buyer broker compensation. So does the seller want you to disclose that the seller is willing to contribute towards buyer agent compensation or not, right? That's the question here. So you have two boxes that you need to consider. And then paragraph C now says seller approval of optional buyer broker compensation. In the event seller desires that broker disclose and or market subject to MLS rules a specific amount or rate for buyer broker compensation, broker must obtain seller's approval in writing in advance of any such disclosure or marketing in any agreement to pay or payment and must specify the amount or rate disclosed or marketing. So that's where we get this new addendum to the listing agreement. So we have a brand new separate addendum to be completed if the seller would like the listing agent to disclose that the seller is willing to contribute towards buyer broker compensation, and it specifies the amount. So the operative part of this brand new listing agreement addendum, optional buyer broker compensation, right, is the title. Says the parties agree to supplement the listing agreement, right? So this is an addendum to the listing agreement that you would attach to include the following, right? 1, seller is willing to pay buyer broker compensation up to the following amount. So you can put a percent or a dollar figure. And 2, seller authorizes broker to disclose and or market seller's willingness to pay buyer broker compensation. So again, it's really tricky, right? Because this is all new. But this amount is not binding, right? So if the seller in the discussion with the listing agent says, okay, yeah, fine, I am willing to pay X towards buyer's broker's compensation, right? And you put it in this addendum to the listing agreement, okay? This is for marketing purposes only. This is to get the conversation started and maybe kind of set the expectation for what you as the listing agent can, anticipate the seller may see as far as the offers that are coming in. But again, let's say seller agrees to pay X and we put it in the listing agreement. An offer comes in from a buyer and doesn't ask for any buyer broker compensation, right? Is seller obligated to still pay X because that's what they put in this listing agreement addendum? No, right? The amount that the seller is actually obligated to pay towards the buyer broker compensation is what ends up in the contract, okay? So this, again, is just starting the conversation. So if that offer comes in and they don't ask for buyer broker compensation or they ask for more than X, right? Again, it's whatever the parties can negotiate, or even if they ask for less, right? It's whatever the parties can negotiate and whatever ends up in that final ratified agreement between the parties. So, the other question here is, why would a seller want the listing agent to disclose or market seller's willingness to pay buyer broker compensation of a specific amount, right? Why would you put out there, yeah, seller is willing to pay X when you don't even know what that buyer has agreed to pay to their broker, right? It could be less than X. And so then you're negotiating against yourself by putting it out there that the seller has agreed to pay X amount. So it's tricky. It's going to be a whole adjustment here as to how we talk about, what people are asking for, what people are willing to pay, right? And, I think it's just going to take some adjustment. But in my mind, it would behoove the seller, right, to maybe not put it out there as a set amount until you know what the buyer is looking for, what the buyer has already agreed to pay towards their agent. So that's just my 2 cents. Okay. Again, this paragraph 8 of the listing agreement is now gone. This was added July 1st, so it only made it a month and a half. It was an optional, again, non-binding paragraph. Seller was authorizing the listing agent to advertise a seller subsidy, right? Potentially. So again, it's gone, so we don't have to worry too much about it, except that Bright has added, right, this optional seller concession field, which went into effect, I think, June 12th. So if you have entered a listing, right, you will see that now we have a field where you can include in the listing that the seller is, willing to pay a certain percentage or a certain dollar figure in seller concessions.
Heidi, can I interrupt a second?
Yes, please do.
So guys, we have people on this call from firms other than Fathom Realty. So anything that you put in the chat must not have a figure. It can be X, Y, Z, A, whatever, but we cannot put figures in the chat. This would be a violation of antitrust, and I don't look good in handcuffs.
Yes, please. I don't want to see that. Okay, so we've got this optional seller concession field now, right? Which is really confusing to add this in a time where we're now removing the offer of cooperative compensation, right? So this is not to be used, right, to telegraph any, indication of, seller's willingness to pay buyer agent compensation. This is just for seller concession. So seller payment towards buyer's closing costs, right? Which we always had in the contract itself. We had for a short period of time in the listing agreement as well, but that's gone. But now it's going to be a field in MLS, right? So, it's tricky because we're changing 2 things at once here. And the seller concession affects the buyer's loan, whereas a seller payment towards buyer broker compensation doesn't. So let's talk a little bit about that. So one of the issues with all of these changes, right, is how is a buyer going to pay for this stuff, right? How is a buyer going to qualify for a loan, right, if they are now expected to pay their agent? Or maybe the seller is going to contribute a portion of that payment, right? So now we have all of these interested party contribution concerns. So Fannie Mae, Freddie Mac, and FHA have all confirmed that seller-paid buyer broker compensation does not count against the buyer in their loan calculations, right? Because that amount is coming directly from the seller to the buyer broker. It does not go onto the buyer side of the CD, so it's not affecting all of the loan calculations, right? The VA issued that interim policy on June 12th that does allow a VA buyer to pay their buyer broker. So, the short version of the story is if a seller would like to contribute towards buyer broker compensation, right, they can do that as a direct payment, right, as seller paid buyer broker compensation, versus calling it a seller concession or seller subsidy is what we have in our contract, right? Because that seller subsidy is going to be subject to lender regulation, right? So a lot of moving parts there, but the lenders are going to be able to kind of walk us through this and sort of help with the transition as well. All right, form change number 4 to the sales contract, right? We have this brand new paragraph 2E on the first page of our contract here. So we have seller payment towards buyer broker compensation now. So you still have seller subsidy, right, which we always had there. And again, that is seller's payment towards buyer's closing costs, okay? Now we have this separate line for seller payment towards buyer broker compensation. So you could have one or the other, you could have both, you could have neither, right? It all just provides flexibility for, a situation where a seller wants to contribute either towards the buyer's closing costs as a seller subsidy or towards the buyer broker compensation as that direct seller payment. Which again, seller subsidy is going to be subject to lender limits. Seller payment towards buyer broker compensation is not. To zoom in a little bit on 2E, you see under 2E, this obligation is enforceable by buyer's brokerage against seller and may be modified only by subsequent written agreement by buyer's brokerage. So the buyer... The buyer's broker can enforce this provision, right? So the amount that the seller has agreed to pay towards buyer broker compensation against a seller, even though the broker is not a party to the contract, right? Because there is this whole legal concept of third-party beneficiary principles, okay? So even though only the buyer and the seller are the parties to the contract, the buyer's broker is now a beneficiary, right, of the terms of that contract. So if in the event, right, someone is breaching their obligation, the buyer's broker is able to enforce this obligation against the seller. And interestingly, the buyer broker does not have to initial off on this provision, right? They don't need to approve the amount that the seller has agreed to pay towards buyer broker compensation unless, right, there's always a but. The amount is modified unless the amount is modified by the parties after ratification. So let's say we get through the home inspection, seller's going to pay a bunch of money for home inspection repairs, and they say, okay, I'll pay for all of these home inspection repairs, but now I'm not going to pay your agent. You would have to go back and get the buyer broker to initial off on any change to 2E after ratification, okay? Okay, and then paragraph 22, I just wanted to point out that this states that the parties irrevocably instruct the settlement agent to pay broker compensation at settlement as set forth in the parties' respective brokerage representation agreements. This means the title company, right, and the lender are now going to need a copy of the buyer broker agreement because we have to collect that amount at settlement pursuant to the terms of that agreement. I've had a lot of questions from agents saying, oh my gosh, what if we get to closing and it turns out that the buyer doesn't have the money, to pay me, right, as the buyer's agent? what's going to happen? And, my answer is I'm going to show the contract to the buyer and say, hey, you irrevocably instructed me as the settlement agent to collect the amount that you agreed to pay. We're not closing if we're not, collecting the amount that you agreed to pay. So this hopefully makes it really clear that, they are expected to hold up to their bargain on that. All right, last form change here, number 5, buyer broker agreement. Okay. Buyer broker compensation, paragraph 8, buyer broker compensation, buyer will pay broker an amount of blank, right? Buyer is responsible for payment of broker compensation. If broker receives any compensation from seller or seller's representative, that amount will be credited towards buyer's obligation. And then it goes down to paragraph E, which is new, right? Broker may not receive any compensation which exceeds the amount set forth in the agreement. So again, let's say the buyer has agreed to pay their agent X, right? And then the buyer's agent negotiates a contract where the seller is actually paying more than X, right? Towards buyer broker compensation. The buyer broker cannot accept more than what is specified in the compensation paragraph here unless you go back and amend that buyer broker agreement. Okay, so if you're in a situation where it turns out that you are going to receive additional compensation from the seller, right, you've got to go back and amend your broker compensation paragraph to allow for that. As of July 1st, there was a checkbox under the compensation paragraph, which has now been removed. The checkbox specified or instructed the buyer's agent to ask for seller contribution towards buyer broker compensation. They have decided we're not going to have a checkbox. That's just a conversation that you need to have with your buyer to determine if that's something that they are going to need you to include in the negotiations. So the checkbox is gone, but it's still a conversation to be had with the client if they are going to need assistance paying the agreed upon compensation. So just real quick again to review 5 changes. So residential sales contract, we now have business days, which helps with EMD delivery. HOA right to cancel is now fully negotiable as far as the number of days. The listing agreement, we've got that listing term and agreement term. We now have paragraph 6 to the listing agreement, which is just listing broker compensation only. And then that 6B, additional listing broker compensation for an unrepresented buyer. The residential sales contract now has that paragraph 2E, seller payment towards buyer broker compensation. And the buyer broker agreement specifies that a buyer broker may not receive excess compensation. Timeline here, right? So we've made it to August 14th somehow. So June 12th, right? That seller concession field became available in Bright. July 1st, the new forms went into effect. August 14th, we changed the forms, and also that Bright compensation field is removed. So the last kind of hurdle we've got here, August 17th, is when the NAR settlement agreement actually goes into effect. So real quick on what does that mean? So we were in this weird period from July 1st to August 14th, where we had the offer of compensation in MLS, but we also had that line, right, 2E, where the seller is agreeing to pay buyer broker compensation. So I can tell you on probably 50% of the contracts I received from July 1st through now, it was included in the contract, right? The amount the seller was willing to pay, which really, technically is in addition to whatever was included in MLS. So thankfully, as of today, because that field is down, we no longer have this, trap basically where the seller may be obligating themselves to pay double. After August 14th, right? So NVAR has said new brokerage agreements are required beginning on August 17th, right? Talk to your broker about how to handle it if you're in a situation where you're currently under, a listing agreement with a client and they are unwilling or unable to execute a new brokerage agreement because the terms of the August 17th brokerage agreements are not going to fully comply with the terms of the NAR settlement. One thing that was really interesting on the NVAR legal blog, and then I'll wrap up here, they got a question: can buyers and buyer brokers rely on an offer of compensation that was on MLS prior to the effective date of the MLS policy changes? So prior to today, right, there's an offer of cooperative compensation in MLS. And the answer, right, from NVAR was if the sales contract is executed before the policy change, right, so before today, buyer broker can rely on that offer of compensation, even if the closing is later, right? But if the sales contract was not executed before today, right, that offer that used to be on MLS is no longer valid, right? It's gone. It's got to be whatever the parties include in the residential sales contract line 2E if the seller is willing to contribute towards the buyer broker compensation. That was all that I had, guys. I have my contact information here. Again, are there any questions? I know you guys have to jump off to another meeting.
So the one question that was early on, I didn't want to interrupt you because you had moved on, was, so we got the business days, but what happens if there's, and I think I already know the answer, but I'm going to let you answer it, is so now there's a snowstorm, the state and local and federal government is open, but schools are closed. That has no bearing on anything, correct?
Right. Schools are not it. It's local government offices, I guess, is what it's the definition is there.
Anything else from anyone? Okay, Heidi, I greatly appreciate it. Can you, will you be able to send me this briefing and I can send that to my agents?
I certainly will. And thank you so much for having me.
All right, thank you very much, Heidi. You did, as normal, a great job. And although some of this is clear as mud, that's not your fault.
We'll all get through it together.
Absolutely. So thanks.
Yep. Hold on, you're muted, Mark.
So everybody can shift over to the town hall. If there are any questions, I'm going to come out with a video too, a little bit on my direction on some of this. But thanks everybody, and again, thanks for Heidi. This is being recorded. Once I can get it formatted, it'll be up on Facebook, and it will also be it'll also be emailed out on my Monday email. Thanks everybody. Bye.